Today is March 18th, 2026. This is a meeting of cities and counties subcommittee. We would like to welcome members and guests. The committee will be in order. Madam Clerk, please open the voting roll, please. Register your presence by voting present. Madam Clerk, take the roll.
Mr. Chairman, you have 6 members present. You have a quorum.
Thank you, Madam Clerk. At this time, does any member have any personal orders or any announcements? Seeing none, we will go ahead and take up today's calendar. Without objection, we will take up item 24, House Bill 2306 by Chair Lady Carringer. We have a motion and a second. Vice Chairman Wright, for what purpose?
I'm sorry. Thanks, Mr. Chairman. I'd like to move this item to the January calendar.
Without objection, House Bill 2306 is moved to the January calendar. Item number 1, House Bill 2394 by Representative Renault. Is there a motion? We have a motion. We have a second. We have a motion and a second. Representative Renault, you are recognized on House Bill 2394.
Thank you, Mr. Chairman and committee. This bill simply establishes the legislature's intent that fire protection be treated as a priority public service when county funding or when counties make funding decisions. It is permissive. So it specifically is saying that if a county legislative body decides to do a countywide fire department, then they should fund it at the same level they do the sheriff's budget.
Members, you've heard the explanation of the bill. Vice Chairman Wright, you're recognized.
Thank you, Mr. Chairman. I want to make sure I heard the word should, not shall.
Representative Renault.
I actually did not say either of those, but I did say permissive.
No, I think I heard the word should. Thank you, Mr. Chairman.
Anyone else? Representative Butler, you're recognized.
Thank you, Mr. Chairman. I'm curious. So if I have 12 volunteer fire departments in Overton County, and I think the county puts $9,000 per county fire department. So just over $100,000. If they were to go to a county fire department, would they not be required under this legislation to fund that at the same amount as the sheriff's department?
Representative Renault.
My understanding is that if the county chooses to do a countywide fire department, it would not affect any of the volunteer ones. If they chose to do a countywide one, that they would fund it the same as they do the sheriff's.
Representative Butler.
Thank you, Mr. Chairman. How would a small county be able to afford to do that? I mean, we have looked at, I know Overton County has looked at doing a countywide fire department, you're looking at, I mean, just the county budget for the sheriff's department in Overton County, which is a county of less than 23,000, is $4.8 million. So we would essentially go from a little over $100,000 to $4.8 million.
Representative Renault.
Then my understanding is that the county would just choose not to do a countywide fire department. They would just maintain their volunteer fire department. So it would give them if this is permissive, and that if they choose to do a countywide fire department, that they would make it a legislative priority through that body to fund it.
Representative Butler.
Thank you, Mr. Chairman. So would this not discourage counties from doing a countywide fire department? I mean, a fire truck's $500,000, $1 million. Would this not deter counties from doing this?
Representative Renault.
I am not sure of the Senator Gardenhire's intent as far as that goes. I don't believe that they're trying to discourage it. It's just saying if they choose to do one, they want them to make fire because it is such a huge part of public safety that they want them to also prioritize the funding of it through the municipality.
Representative Butler.
Thank you, Mr. Chairman. One follow-up. I'm very supportive of the volunteer fire departments, and I'm appreciative that we have those, because if we did not, we would have much higher homeowner insurance rates. So they're a tremendous resource and value. And most of my district is served by volunteer fire departments. And I think this bill, the unintended consequences with this bill is going to discourage people from having county fire departments because of this funding requirement. I'm all for providing as much funding as we can to the volunteer fire departments and the county fire department if we have them. But I don't know that a county can afford to do this at the same level it's funding the sheriff's department, because I think you would also have a maintenance of effort. Once you started that, you would have to continue to fund at the same level. And I don't know that that's attainable. Thank you, Mr. Chairman.
Thank you. Vice Chairman Wright, you're recognized.
Thank you, Mr. Chairman. Now, in Knox County, there is a subscription fire department. So whenever I look at this, I don't know that it's going to affect Knox County. But this funding issue stuff now doesn't come under some of the discussions that you and I had about the bill. If there's going to be a requirement of funding, I can understand the word intent. But when we, thank you, Mr. Chairman.
Representative Renaud.
Yeah, many volunteer fire departments do operate on subscriptions, so it would not change their ability to do that. I think one of the concerns that I understood from the Senate sponsor is that a lot of these volunteer fire departments do have to work very hard to raise funding. So he was trying to provide an avenue that would provide for funding through the municipal budget.
Vice Chairman Wright, follow up. Any other questions, comments? Is there objection to the question? Hearing none, we're voting on House Bill 2394. Clerk, please open the voting rolls, please. Members, please cast their vote. Has every member voted? Does every member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 0 ayes, 5 noes, and 1 present not voting.
The noes prevail. House Bill 2394 does not move forward.
Thank you.
Move to item 2, House Bill 2406 by Representative Scarborough. We have a motion, a second. Representative Scarborough, you're recognized on House Bill 2406.
Thank you, Mr. Chairman. I have an amendment, tracking code 015609.
Is there a motion? We have a motion on Amendment 15609. You're recognized on the amendment.
Thank you, Chairman. The bill clarifies the structures owned by a nonprofit entity, including those held by wholly owned subsidiaries, qualify for exemption from real and personal property taxes. This bill supports a tremendous investment in a private park in my community of Clinton, Tennessee. The Aspire Park is a private park that is free to the public, which offers 370 acres of beautiful landscapes, endless activities, unforgettable experiences. I encourage you all, if you get an opportunity to check out the website, I'll be happy to meet you there someday if you want to visit. The bill also establishes a 400-acre cap on property tax exemption, providing a clear limit on the scope of the exemption. I'll stand by for questions.
You've heard the explanation of the amendment. Representative Mitchell, you're recognized on the amendment.
Yeah, thank you, sir. Thank you, Mr. Chairman. Is this a nonprofit or is this owned by an individual?
Representative Scarborough.
Thank you, sir. It's structured as a nonprofit, but there's a restaurant on the premises, and that's the reason for the exemption. This restaurant alone has brought in sales tax revenues over $500,000 in the last 2 years. But we're bringing in probably 500,000 visitors a year. It's incredible each day how many people pack into this place. But there's a restaurant there, and that's the only thing we're talking about here as far as the exemption goes.
Representative Mitchell.
I just think it has serious constitutional issues with Article 2, Section 28, and in the amendment where it says regardless of use. I think we're setting a really bad precedent by putting that language in here. Thank you.
Sponsor.
Well, this, again, when you set up, this is important. The model allows nonprofit recreational development to operate without reliance on taxpayer-funded construction or ongoing public subsidies. That's why we really think it's important to be able to support private parks like that.
At this time, I'd like to go out of session and ask legal to opine on this bill. We're out of session.
Just a second, Mr. Chairman.
Take your time, sir.
Mr. Chairman.
Yes,
I'm
Representative
not
Scarborough.
sure, I'm not sure where you're on the calendar here. Is this your last calendar?
Yes, sir, it is.
Okay, I was going to say if you needed to
We
roll
can
it.
take our time.
Well,
We're not
okay.
going to rush you or the members in the deliberation.
Yes, sir.
Mr. Chairman, Josh Houston Legal Services, can you repeat the question for me?
Representative Mitchell, if you'll please, Representative Mitchell.
Yeah. Does this conflict with Article 2, Section 28 of the Tennessee State Constitution?
Thank you, Mr. Chairman. Not that I'm aware. I've not found anything that would make this unconstitutional. But the Constitution does allow for exemptions for charitable and nonprofit entities and that sort of thing. So I feel that falls in that exception.
Any questions while we're out of session to legal? For legal? Okay, we'll go back into session. Representative Butler, you're recognized.
Thank you, Mr. Chairman. Sharing part of Anderson County with the sponsor, I've been to this park myself. It's a beautiful park that is open to the public. And it's my understanding, and correct me if I'm wrong, sponsor, the only reason that we're running this piece of legislation is the park is a nonprofit. And so the part of the park, the restaurant that is on this park is paying sales tax. Or collecting sales tax, I should say, which is being paid. And so that was the only need for this piece of legislation. Is that not correct, Mr. Sponsor? And I'll let you respond to that.
Representative Scarborough.
Since 24, they paid in $461,000 sales tax revenue. Again, this would not exist if not for the investment by this private individual to put this park up. And again, you got green spaces, bicycle trails, 6 miles of walking trails. It is an amazing development. And again, the only structure there is that restaurant.
Representative Butler.
Thank you, Mr. Chairman. I would just encourage my colleagues to support this legislation. This park is a beautiful park that's been donated and paid for with private money that the public has access to, and the citizens in the community are able to use this. So with that, I would ask for y'all's support. Thank you.
This time, legal would like for us to go back out of session. Out of session.
Thank you, Mr. Chairman. Josh Houston Legal Services. I need to correct myself about what I just said. I finally found the provision I was looking for. It says that that all property is subject to taxation, but the legislature may accept such things as may be held as used for purposes purely for religious, charitable, scientific, literary, or educational. And from the description of the sponsor, this sounds like that it's not purely for these religious, charitable, scientific, literary, or educational. So this may be constitutionally suspect.
Thank you, legal. We'll go back into session, and I'll recognize the sponsor.
Thank you, sir. Again, this is this type of model is providing us unbelievable tax savings and cost savings to the community because, again, it was built without city and county dollars. It was solely done by an individual to development. And again, if we could approve this model, then we're absolutely setting it up to where it could be followed throughout the state of Tennessee.
Yes, Representative Dixie.
All right. Thank you. I understand what you're saying, that it's a beautiful place, and I'm all for green spaces and bicycles and everything. But what concerns me is it says regardless of use. So if we approve this, he could do whatever he wants to after this. He doesn't necessarily have to continue the usage that is now. So we have to be careful if we set that precedence that if we grant him this particular, I'm just assuming this of him, this person, this right to do this, he can do whatever he wants to on that land. He could take away all the green spaces. And then we will have no recourse or no say in it. The city has no say. Nobody has any say because it says regardless of use. Am I correct or am I incorrect?
Representative Scarborough.
Well, I think that the amendment we applied to the bill narrowly tightens the focus to just that one building. I could be wrong, but I think I'm correct. We tightened that language up to make sure that as of the effective date, that's all he can do on that property.
Representative Dixie. Representative Scarborough, The building, is it a wholly owned subsidiary of the nonprofit?
I can't answer that question. I'm sorry, I don't know the answer, sir.
Okay, any other questions? Comments? We're voting on Amendment 15609. All in favor say aye. Aye. Opposed say no. The ayes prevail. We're back on the bill 2406 as amended. Is there any other questions? Comments? Representative Butler.
Mr. Chairman, I do want to get a clarification. I think the property is all owned by a nonprofit, which is run by a board, not by a particular individual. And to answer my colleague's questions at the other end of the dice, it's not owned by one man or one woman. It is owned by a nonprofit that is managed by a board of directors.
Correct.
So just to clarify, I want to put that on the record. Thank you.
Any other questions or comments? Is there objections, question? Hearing none, we're voting on House Bill 2406 as amended. Madam Clerk, open the voting board. Will every member cast their vote? Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 5 ayes and 2 noes.
The ayes prevail. House Bill 2406 as amended moves to the next available calendar, state and local government.
Thank you, Chairman. Thank you, members. Great questions.
We are now on item number 3, House Bill 2340 by Leader Camper.
Thank you,
We're
Mr.
graced by your presence, Madam Leader.
Oh, thank you, Mr. Chairman and committee. Chairman and committee, thank you. Appreciate the motion in a second. I know, I think you told me you had someone that wanted to testify also on this bill, so I was hoping we could allow them to.
Not to my
They
knowledge.
didn't
No,
sign up?
ma'am.
Oh, okay. All right. So, Mr. Chairman, Mr. And committee, what this bill does is it deals with the population growth that we've been seeing in some of our major cities and how there's been a lot of investors coming up buying real estate, creating these areas of instead of a lot of home ownership, there's a lot of home rentership. So it's having a negative impact on some of our communities. What this bill would do would prohibit entities that own more than 100 or more single-family rental homes, not homes for sale, in qualifying counties from purchasing additional single-family homes for non-residential use. We're trying to get more people owning homes and not necessarily renting homes in our community. It exempts an entity that is building affordable housing. So if you're coming in the community and you're buying them up and you convert them into affordable housing, that's fine. It also authorizes the Attorney General or an aggrieved individual to bring civil action. It permits the courts to join affiliated parties and impose joint and several liabilities to ensure enforcement. With that, Mr. Chairman, I know there was a lot of concerns about this bill. Someone did tell me they wanted to come and speak, so I expected them to be here. Maybe they couldn't get back from last week, but I was hoping to allow them an opportunity to speak on the bill. So if we could roll it to the hill, then I'll get them an opportunity to come back. I don't want to go back on my word to that individual. I don't know if that's something the committee is open for.
Vice Chairman Wright, for what purpose?
Thank you, Mr. Chairman. I'd move this to the January calendar.
Without objection. Hearing no objection, Madam Clerk, open the voting roll, please. We're voting on rolling House Bill 2340 to the January calendar. Members, will you please cast your vote? Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 5 ayes and 2 noes.
The ayes prevail. House Bill 2340 is rolled to the January calendar.
Thank you, Mr. Chairman and committee.
Thank you, Leader Camper. Brings us to item 4 on today's agenda, House Bill 1893 by Representative Hemmer. Without objection, House Bill 1893 is rolled to the heel. Item 5, House Bill 993 by Representative Hardaway. Without objection, House Bill 993 is rolled to the heel. Brings us item 6, House Bill 1451 by Representative Hardaway. Without objection, House Bill 1451 is rolled to the heel. Item 7, House Bill 2397 by Representative Renaud. Is there a motion?
Motion.
Is there a second? We have a motion, a second. You're recognized on House Bill 2397. You do have an amendment.
Yes, Mr. Chairman, 15558.
Is there a motion on Amendment 1558? We have a motion and a second. Representative Renaud, you're recognized on the amendment.
Thank you, Mr. Chairman and committee. Tennessee already recognizes the importance of military service by providing a hiring preference for veterans in state government employment. The goal of this legislation is to build on that foundation by modernizing the policy and extending similar protections for veterans to local governments across our state. The bill does several different things. I worked with the Department of U.S. Department of War, the Tennessee Department of Veteran Affairs, as well as the Tennessee Department of Human Resources to come up with this final amendment on the bill. It first updates Tennessee's veteran preference to include military spouses, including spouses of active duty service members, National Guard members, and reserve members. Military families relocate frequently because of service, and spouses often face significant barriers to obtaining stable employment during their tenure. This ensures that service and sacrifice are recognized as well. Second, the bill does expand the definition of military to include the Guard, National Guard, and the Reserve. And third, the bill addresses what many military families refer to as the marriage penalty. Current language on the state statute removes eligibility for surviving spouses if they remarry. This amendment removes that restriction. Remarriage does not erase the sacrifice that was made or the loss that was endured. A surviving spouse who has lost a service member in the line of duty will always remain part of the Gold Star community. And this change ensures that we are not discouraging them from moving on and rebuilding their lives. Finally, this legislation mirrors Tennessee's existing state veterans preference framework and extends it to local governments, ensuring consistent standards across state and local public employment. This bill requires that when interviews are conducted and a qualified veteran or active duty military spouse is in the applicant pool, they must be invited to interview. If they meet the minimum qualifications and are equally qualified as another applicant, then preference must be given. It also includes a reasonable accountability measure. If a veteran or a military spouse is passed over, the hiring entity must document the reason, and those records are maintained by the human resource departments and retained for 10 years. I just it's important to mention that this bill does not create quotas. It does not require hiring unqualified candidates, and it does not remove any hiring discretion. It simply ensures that veterans and military families receive fair consideration when seeking to serve their communities. If they are qualified, they get an interview. If they're equally qualified, then the service matters. With that, I stand ready for questions.
Heard the explanation of the amendment. Are there questions? Vice Chairman Wright, you're recognized.
So let me make sure that I'm straight on this. There is in code now language about state employment. This is making an extension to local government bodies' employment. Is this a mandatory thing that they extend this, or is it a permissive bill which would allow the local government to take up this amendment?
Representative Renaud.
It is currently already existing in state statute that for state government, it is mandated that veterans do get preference for interviews and hiring, and also for that documentation. So what we are doing is mirroring that state statute down to local governments.
So for clarification, so it's not permissive.
Correct.
Vice Chairman Wright.
Thank you, Mr. Chairman. That creates a difficulty for me.
Representative Renaud.
Thank you. We already do this in state government, so we're just simply asking for the cities to also consider the same for if veterans do apply to local or city governments for employment. That I don't. This bill was actually originally brought to me because a veteran in my city was not allowed to distinguish their veteran service, even though there was a place on the online application. They couldn't actually check the box, so it raised questions about whether veterans were getting preference. It was not required at that time, but the U.S. Department of War, after I filed this legislation, did come and email me and say that they were very supportive of this, because one of the most important things for our military families, especially as they get relocated, is to create a stable economic environment for them. And being able to have gainful employment for them is an important piece of that, especially for the active duty spouse who's supporting their military member.
Thank you. Chairman Crawford, you're recognized.
Thank you, Mr. Chairman and sponsor. I understand that we do this statewide now, but my problem is, why are we sticking our nose in locals? The locals should have the most power. They deal with their people. They know exactly what's going on in their area. So why are we mandating that they have to do this? Can we not make it permissive? Because I don't think anybody would not do that, but here we are again, sending the mandate down to the locals. I have an issue with that. I do not have the issue with the bill as far as helping the veterans. I don't think there's a member of this General Assembly that wouldn't bend over backwards to help the veterans, and I'm willing to do that. But it just bothers me that you're mandating the locals to do something. Thank you, Mr. Chair.
Representative Renaud, follow up.
Thank you, Chairman. The reason why, again, the legislation I originally filed it is because I did have members veterans in my community who did apply for jobs and was told that they did not get preference. And so these military members bring an immense amount of service and qualifications, and for them to be passed over, did not even get an interview. It was hurtful to the veterans who had already given much to our country to serve, and would like to carry that service over into local government.
Any other questions, comments? We're voting on Amendment 15558. All in favor of the amendment say aye. Aye. Opposed say no. The amendment is on the bill. We're back on House Bill 2397 as amended. Is there any other questions, comments for the sponsor? Is there objection to the question? Seeing, hearing none, we're voting on House Bill 2397 as amended. Madam Clerk, open the voting board. Members, please cast your vote. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 3 ayes, 2 noes, and 1 present not voting.
The ayes prevail. 2397 as amended moves to next available calendar, state and local government.
Thank you, Chairman.
Item 8, House Bill 1667 by Representative Mayberry. We have a motion and a second. Representative Mayberry, you're recognized on House Bill 1667.
Thank you, Mr. Chairman. House Bill 1667 allows cities and metropolitan governments to adopt a tiered fine for repeated ordinances violations within a 12-month period and creates a meaningful incentive for compliance while staying within existing state laws. The city of Clarksville asked me to run this bill, and that's where it comes from today.
Members, you've heard the explanation of the bill. You have questions about the bill? Comments? Is there objection to the question? Hearing, seeing none, we're voting on House Bill 1667. Madam Clerk, open the board for voting. So, members, please cast your vote. Has every member voted? Does any member wish to change your vote? Madam Clerk, take the vote.
Mr. Chairman, you have 5 ayes and 2 noes.
The ayes prevail. House Bill 1667 moves to next available calendar, state and local government.
Thank you, Mr. Chairman and Committee.
Item 9, House Bill 2325 by Representative Brooks. We have a motion and a second to explain your bill, Representative Brooks.
Thank you, Mr. Chairman and Committee. I'm bringing this bill This legislation on behalf of my constituents, as I was in the community this summer, the number one concern that kept coming up was property taxes. I'm sure that you all have had similar instances in your districts. This legislation would put a cap on property taxes from the city and county. It would cap the county property tax at $3 per $100 of assessed value. It would cap the city property tax from $250 per $100 of assessed value. With that explanation, I would ask for a favorable vote.
Thank you. Vice Chairman Wright, you're recognized for what purpose?
Thank you, Mr. Chairman. I'd like to move this to I move to move this to the January calendar.
Is there a second? We have a motion second, move this to the January calendar. Is there objection to the question? You object? Is there objection to the question? All in favor of previous question, say aye. Aye. Say no. Against, say no. The ayes prevail. We're voting on the motion to roll this to the January calendar. Madam Clerk, open the voting board. We're voting to move this to the January calendar. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 5 ayes and 2 noes.
The ayes prevail. House Bill 2325 is rolled to the January calendar. Item 10, House Bill 955 by Representative Brooks. We have a motion and a second. Representative Brooks, you're recognized on 955, House Bill 955.
Every bill that I bring before every committee is because of what my constituents want. So, thank you, Mr. Chairman and committee. This bill would allow local government by 2/3 vote to adopt an ordinance of resolution to control the amount of rent charged for leasing private residential properties, including the establishment and adjustment of maximum rent and rental application fees. The bill also set forth that prior to adopting an ordinance or resolution to control the amount of rent charged, the local government must establish a determination process, establish a board, commission, agency to administer the regulation, and establish a process for a person who is aggrieved. This bill will also create the increased housing program and increased housing fund to be administered through THDA. And lastly, this bill authorized THDA to make grants from funds to eligible developers and first-time home buyers to assist in gap financing and down payment assistance. With that, Mr. Chairman, I ask for a favorable vote.
Thank you, sponsor. Vice Chairman Wright, you're recognized.
Thank you, Mr. Chairman. Move the January calendar.
Motion and second to roll this bill to the January calendar. Is there objection? We have objection. We're voting on rolling House Bill 955 to the January calendar. Madam Clerk, open the voting board. Members, please cast their vote. Does any member wish to change your vote? Madam Clerk, take the vote.
Mr. Chairman, you have 5 ayes and 2 noes.
The ayes prevail. House Bill 955 is rolled to the January calendar. Item 11, House Bill 946 by Representative Brooks. We have a motion and a second. Representative Brooks, you're recognized.
Yes, thank you, Mr. Chairman and committee. This legislation would allow local government to require any high energy use facility to submit a site assessment prior to any approval of rezoning requests. It also instructs the local government to require the application to perform and submit a site assessment examining the sound profile of the high energy use facility on residential areas and schools within 500 feet. The local government would only be obligated to require that assessment if the facility were to be within 500 feet of the residential area of school or school. Any other time would be at their discretion. This would also allow local government to see the environmental impact of high energy use facility without putting the financial burden on the local government. With that, Mr. Chairman, I would ask for a favorable vote.
Thank you, sponsor. Vice Chairman Wright, you're recognized.
Thank you, Mr. Chairman. Move to the January calendar.
We have a motion and a second to roll this bill to the January calendar. Is there objection? Hearing no objection, Madam Clerk, open the voting board. If you're in favor of rolling this January calendar, vote yes. If you're opposed, vote no. Madam Clerk, take the vote.
Mr. Chairman, you have 5 ayes and 2 noes.
The ayes prevail. House Bill 946 is rolled to the January calendar. Item 12, House Bill 2119 by Chairman Crawford. We have a motion and a second. Chairman Crawford, you're recognized.
Thank you, Mr. Chairman. This bill is dealing with tourism and hospitality. We've got a small amendment. The amendment rewrites the bill or makes the bill. This bill states that revenue received by local government that is used in engaging
Do we
tourism.
have a motion and a second on Amendment 14639?
That's correct.
Continue.
All right, sorry about that. This bill states that revenue received by the local government that is used in engaging tourism promotion on behalf of the local government must release within 120 days the final budget approval. We're having a small problem with the revenues that are generated through that are not being sent to tourism and hospitality. It's being held up. So this would require them to be able to send it within the 120-day period. So that's what the amendment.
Mr. Chairman, what's the current requirement for disbursement? 120 days is what the amendment calls for. Is that correct?
That is correct.
That's
yeah.
correct. Any questions? Comments? Members ready for the question? Amendment 14639, all in favor say aye. Aye. Opposed say no. The ayes prevail. We're back on House Bill 2119 as amended. Is there any other questions or comments for the sponsor? Is there objection to the question? Hearing none, seeing none. Madam Clerk, open the voting board. We're voting on House Bill 2119 as amended. Member, please vote. Does every member cast their vote? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 7 ayes and 0 noes.
The ayes prevail. House Bill 2119 as amended moves to the next available calendar, state and local government. Item number 13, House Bill 2104 by Chair Lady Littleton. We have a motion and a second. Chair Lady Littleton, you're recognized. I believe you have an amendment.
Yes, thank you, Chairman. I do have an amendment that makes the bill, it's rewrites the bill, 14662.
Is there a motion on amendment 14662?
Motion. Second.
We have a motion and a second. You're recognized on your amendment.
Thank you, Mr. Chairman. This authorizes a county to sell real property that has been declared surplus, obsolete, or unusable in an arm's length transaction to a third party for the price not less than the fair market value as determined by at least 2 licensed appraisers without requiring public auction or sealed bids upon approval by the majority vote of the county legislative body.
Thank you, Chair Lady Littleton, for the explanation and for the amendment. Vice Chairman Wright, you're recognized on the amendment.
Thank you, Mr. Chairman. Could this possibly be an appraised price which would be less than overdue property taxes if there are property taxes in arrear?
Chair Lady Littleton.
Thank you, Mr. Chairman. I don't think so.
So
Vice Chairman Wright.
thank you, Mr. Chairman. So the floor of the arm's length sale is going to be property tax or then greater.
True.
Chair Lady Littleton.
Yes, sir. That's correct.
Vice Chairman Wright, does that take care of? Any other questions? Chair Lady Littleton on the amendment.
Thank you, Mr. Chairman. Yes, I've been asked several times for a few years about trying to get something like this done. So this is a beginning for us to do that. So it's not mine.
That's the phone that's no one's claimed. Yeah. Is there anyone from TSA here? Chair Lady Littleton, the chair apologizes, and you please continue.
Thank you, Mr. Chairman. I'm sure someone's missing their phone. I mean, we all keep ours attached to us, so maybe though that one does not, but they're getting a lot of calls, so they're popular. But anyway, I was just, I'm glad that we could bring this bill because I have been asked for several years, can't we do something about this? So I think now that we're finally getting to do that. So thank you.
Any other questions, comments? Is there objection to the question? We're voting on Amendment 14662. All in favor, say aye.
Aye.
Opposed, say no. The ayes prevail. We're back on House Bill 21-4 as amended. Is there any other questions or comments? Is there objection to the question? Hearing none, seeing none, Madam Clerk, open the voting board. We're voting on House Bill 2104 as amended. Will every member vote? Does every member cast their vote? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 7 ayes and 0 noes.
The ayes prevail. House Bill 2104 as amended moves to the next available calendar, state and local government. Item number 14, House Bill 22636 by Representative Dixie. Representative Dixie, you're recognized on House Bill 2236.
Mr. Chairman, this is probably a revolutionary bill that's going to change the way we do business in Tennessee. But unfortunately, my senator counterpart did not put this on notice in time. So I'd like to take it off notice and not waste the committee's time.
Without objection, House Bill 2236 is off notice. Representative Dixie, privilege of the chair, thank you. Item number 15, House Bill 2319 by Vice Chairman Wright. Is there a motion? Motion. Is there a second? We have a motion and a second. Vice Chairman Wright, you're recognized on House Bill 2319 barely.
Thank you, Mr. Chairman. This bill is, as it's introduced, prohibits an employee of a local government from serving on the legislative body of the local government of which the person is an employee. I stand for questions, ask for your consideration.
You've heard the explanation of the bill. Is there questions, comments? Is there objection to the question? Hearing none, seeing none, we're voting on House Bill 2319. Madam Clerk, open the voting rolls. Members, please cast your vote. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 5 ayes, 0 noes, and 1 present not voting.
The ayes prevail. House Bill 2319 moves to the next available calendar, state and local government. Item number 16, House Bill 402. The chair will now give the gavel, pass the gavel to Chairman Crawford.
Item number 16, House Bill 402 by Chairman Moon.
Motion.
Got a proper motion and second. Chairman Moon, you're recognized on your bill. I do see it has an amendment. Can you please give us your drafting code?
12675.
12675, that's correct. Do I have a motion on the amendment? Proper motion. Is there a second? Second. Chairman Moon, you are recognized on your
The amendment does not rewrite
Amendment.
the bill, Mr. Chairman. It just stipulates that this would require a constitution amendment, and therefore it would be a trigger bill.
Okay. Any questions to the sponsor on the amendment? Chairman Wright.
Thank you, Mr. Chairman. There was pointed out on a prior bill that that bill was not moving in the Senate. If I look at my state-sponsored laptop here, I see that Senate Bill 1101 is in general sub.
I was unaware of that, Mr. Vice Chairman. So with that, I request this bill be taken off notice.
Item number 16, House Bill 402 be taken off notice.
Brings us to item 17, House Bill 889 by Chairman Todd. Without objection, we'll roll Chairman Todd 2 spaces. Hearing no objection, House Bill 889 is rolled 2 spots. Item 18, House Bill 2446 by Chairman Hicks. Without objection, we will roll 2446 2 spaces. This time, Chair will stand for a motion to recess for 5 minutes.
So moved. Second.
Without objection, we're in recess for 5 minutes. Sergeant at Arms, see if you can locate Todd and Hicks. We'll take up item number 19, House Bill 2547 by Leader Cochran.
Second.
On House Bill 2547, you're recognized.
Thank you, Chairman and committee. Recently the General Assembly has taken action to prevent ownership of agricultural land by foreign adversary nations. A loophole, though, that we left in place, an important one that we need to fill now, would be the ownership of mineral rights. And so this bill, the Tennessee Land Sovereignty Act, targets that to make sure that we close that loophole. It strengthens Tennessee's national security firewall by extending existing bans on foreign adversaries acquiring land, and we're extending that to cover critical commercial minerals as well as surface and groundwater. So it closes those loopholes by lowering the prohibited foreign ownership threshold from 33% down to 10%, and then in an aggregate from 50% down to 33%. So in order to catch any kind of insider influence. But essentially that is the overall summary of the bill. We want to make sure that when we say that a foreign adversary cannot own agricultural land, we don't want them to kind of go around that by even though their name might not be on the deed, they still have access to all the mineral rights. So that's the basic summary.
You've heard the explanation. Is there questions, comments? Is there objection to the question? Hearing none, we're voting on House Bill 2547. Madam Clerk, open the voting roll, please. Members, please cast your vote. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 5 ayes and 0 noes.
The ayes prevail. House Bill 2547 moves next available College State and local government.
Thank you, Chairman, committee.
That brings us back to item 17, House Bill 889 by Chairman Todd. We have a motion and a second. Chairman Todd, you're recognized. I believe you have an amendment, sir.
We do, drafting code 4729.
Is there a motion on amendment 4729? Is there a second? We have a motion and a second on amendment 4729. You're recognized on the amendment.
Thank you, Mr. Chairman. This rewrites the bill, and I'll start by saying that this involves timeshare properties. The Board of Equalization's Commercial Listings Procedures Manual has consistently provided that timeshare interest should be classified as residential property. In particular, the manual and previous versions thereof have provided the following description of the taxation of timeshare interest for years. It says the Tennessee Timeshare Act of 1981 provides this method of ownership in real property, and Section 103B states that each timeshare estate constitutes for purposes of title a separate estate or interest in property except for real property tax purposes. Timeshare estates are typically condominium developments. The property that's owned under this act should be classified as residential and valued according to that. And this legislation seeks to just clarify that. It's been the longstanding tradition. It's been what the manual says for a long time. But we've had some folks that have decided that they're going to try to get some more money out of these property owners and have reclassified a few of those as commercial. And so this says that for once and for all, we're putting in the code that these are residential properties and not commercial. So with that, I will be glad to take any questions.
Okay, is there any questions? Let's go with Representative Dixie, and then we do have a speaker. So first, why don't we go out of session, hear the speaker, and come back to the members of the committee. This time we'll go out of session, and we'll hear from Mr. Will Denami. For the record, if you will give your name, who you represent, you have 3 minutes.
Thank you, Mr. Chairman and members of the committee. My name is Will Denami, and I'm here on behalf of the assessors of property who opposed this legislation. And I appreciate my friend, the chairman, bringing it forward today. This is really not a new issue. This has been before the General Assembly several times and in front of the court system. And I'm going to read here from this case. The ALJ found that the resort should be classified as commercial, finding that the taxpayer and its affiliated business entities use the resort directly or indirectly for the commercial purposes of producing income
by providing transient vacation accommodations to thousands of guests each year pursuant to 67.55014. The specific thing I'd like to highlight for your attention is that if you look at the fiscal note of this bill, there are two counties that, to my knowledge, there's no co-sponsor on this legislation of the affected counties. The two counties are Davidson and Sevier County. And one of the things I want to point out, especially in Sevier County, where this is over $1 million fiscal note, the way it works for county government with maintenance of effort, when you give a tax break, which is what this bill is, it's $1 million tax break to these properties in Sevier County. Unless you do something to relieve the maintenance of effort for schools or law enforcement, et cetera, that turns into $1 million tax increase in Sevier County. And so with that, Mr. Chairman, I'd be happy to answer any questions. I ask you to vote no. This $1 million tax break in Sevier County will turn into $1 million tax increase on the taxpayers of Sevier County. Thank you.
You've heard the testimony. Is there any questions for the speaker? Seeing none, hearing none, we thank you for your testimony. We'll go back into session. We're still on Amendment 4729. Mr. Sponsor, you're recognized.
Thank you, sir. The Assessment Appeals Commission, which is made up of former assessors of property and other property tax experts, specifically recognized and concluded that the manual is available and familiar. This is a quote, available and familiar to assessors across the state and is the primary means available to the state to achieve uniform results statewide. It is uncontroverted that county assessors use the manual as guidance. In Crown Park Resort case, the AAC final decision and order February 1st of 2021, the commission went on to conclude that the timeshare properties have traditionally been classified as residential in the state of Tennessee. The commission properly overturned the assessment and ordered that the subject properties be classified as residential rather than commercial and industrial property, and the Chancery Court affirmed this decision. Even the Court of Appeals held that the timeshare property located at Laurel Crest in this specific example in Pigeon Forge should be classified as commercial for property tax assessment, and vacated the judgment in Chancery Court as may be necessary and consistent with its opinion. The court observed that for purposes of taxation, all real property shall be classified according to use. That particular one was more of a commercial use, I understand. I'm a timeshare member. We use this as residential. As a matter of fact, when I stay here in Nashville, I use my timeshare points to stay in a residential unit that I share with two of my colleagues. That's the way we use it, and that's the way most owners use this. So it's not something that we're making money off of. I've used it for years to vacation with my family all over this country. And that's what, again, most of these timeshare owners utilize for. And for Sevier County in particular, to just inadvertently pick one or two of these as they have and decide they're going to start charging them as a commercial rate so they can get more tax money out of them is just wrong. That's against the manual, as this commission stated. And we're just putting it in law that makes sure that they don't continue doing this.
Members, you've heard the explanation. Representative Butler, you're recognized on the amendment.
Thank you, Mr. Chairman. So sponsor, to tax something as commercial property, it would have to be a business. Is that correct?
Chairman Todd.
It would have to be a commercial use, I would think.
Okay. So
Representative Butler.
thank you, Mr. Chairman. So the timeshare that you're staying in, you're sleeping there and it's basically your temporary residence,
Chairman
correct?
Todd.
That is correct.
So it's not you're not making money there. You're not running a business. You're not doing anything but sleeping there just like you would in your residence, but you're sleeping there on a temporary basis.
Chairman Todd.
That is correct. We bought this so that our family could use these properties for us to stay in, for our families to stay in anytime we want to. And we get a certain number of points associated with our ownership, and we can utilize that anywhere in their system. And that's what I'm able to do here as my temporary residence when I'm in town.
Vice Chairman.
Thank you.
Any other questions? Vice Chairman, you're recognized.
Yes, thank you, Mr. Chairman. So testimony that was given referenced a court case. How do you square what you're saying with something that was stated to be a lost court case.
Chairman Todd.
And I'm not sure what case they were referring to. I didn't hear the name of it if they stated that, but this particular decision, and I don't, the exact situation on that property, I don't know that I've ever seen that property, so I'm not really sure what the particulars are in that case. I just know that the commission said it's residential, should be. Chancery Court upheld that. And then I don't know the grounds on the exact grounds that the appeals court overturned that. I didn't hear the argument, didn't read that argument. But the commission has had this manual for a long, long time, maybe decades, I think decades, and say this is what we go by. But this particular county decided that we're going to do something different and just call these commercial now so we can get more money out of them.
Vice Chairman Wright. Representative Dixie.
All right, thank you, Mr. Chairman. I just want to make sure that I think we heard the testimony that it only affects 2 counties, which is Davidson and Sevier counties.
Chairman Todd.
I believe that's correct, if I remember the fiscal note correctly.
Representative Dixie.
So did anyone in Davidson County ask you to run this bill, or have you talked with anyone about how this would impact our revenues? Because this is basically becomes a local mandate, and it will cost us money. And I guess I'm saying that because Davidson County is the economic generator of the state. And anytime you chip away at that, that's chipping away at other things that we can do across the state with our monies. So I'm just wondering, did you consult anybody from Davidson County to see how this would impact our budgetary needs?
Chairman Todd.
I have not consulted anyone in either one of these counties because, again, I believe they violated what the manual has traditionally said through all these decades, that these properties are residential. And just because a county unilaterally decided that some, not all timeshares, but just certain ones, they're going to pick and choose to charge a commercial rate and just see how long they can get away with it. And that's what's happened here. They've gotten away with it for a few years. That's the only reason we have a fiscal note. If they had not done this, if they'd come and asked the legislature for permission to change this, we'd be talking about a different story altogether.
Representative Dixie.
Sorry, sinuses. I guess my question is, I just lost my train of thought, but it will come back to me. But I guess what I'm saying is, and if I'm correct, there was a lawsuit and it stated if what we're doing, if we change this, we would be not in agreement with the lawsuit because it's being appealed right now. Or am I misunderstanding?
Chairman Todd.
Or maybe we can ask legal. Oh, okay.
Chairman Todd.
I don't have all the details of that lawsuit in front of me, and I haven't read up everything on it. So the appeals part, I don't know about. I'm not even sure who exactly brought the lawsuit, if it was that property. So I just know when the case came before the commission, that the former property assessors and other experts in property tax assessment, they said that it's residential. It's always been residential. You can't do this. And then the Chancery Court upheld that. And then I'm not sure what grounds the appeal was made on. I just don't have that information.
Representative Dixie.
All right, this is that. I just want, and I probably should have asked when we were out of session, is the appeal process still going on or has that been settled? Do you know?
Chairman Todd.
I don't know for sure.
Okay.
We do have another person that will speak on this issue if they'd like to come forward and speak if needed. So we can go out of session and hear from, I believe, Ms. Russell. You'll please give your name and who you represent.
Thank you. Addison Russell on behalf of ARDA, which is the Trade Association for the Timeshare Industry. Thank you for your questions, Representative Dixie. And just to give a little bit of background as to what has happened, and I know that Mr. Denami spoke a little bit about the court cases. Once Sevier County made the change to assess certain properties as commercial in 2016, which was after over 30 years of having them as residential, some property owners did file suit on that. Those cases have exhausted their appeals process. What happened was an ALJ ruled in favor of Sevier County, and then as Chairman Todd has commented, it came to the Board of Equalization, where the Board of Equalization assessment appeals ruled in favor of the property owners, and as he has articulated, said that it should be residential. The Chancery Court upheld the Board of Equalization's opinion. Then that was appealed and went to the Court of Appeals. And the Court of Appeals on those properties specifically overturned the Chancery Court's opinion. Property owners appealed to the Supreme Court, but were denied cert. So that kind of leaves us where we are today. And the reason for the legislation is needed is to kind of put into a clarification into code, because we have properties across the state that are being assessed differently. And so a statewide standard is needed for our property owners to know how they will be assessed. And so I think that was all your questions.
Representative Dixie.
Thank you for making it clear as mud. But I think I followed you with the flip flopping.
Yes.
And it seems like at the end of the day, the posture is in that they sided with Sevier County, not the property owners. Correct. So I guess what concerns me a little bit is if we're going against an opinion of the court that's already been decided in a court of law, we're saying, well, we don't really care what the court says, so we're going to make our own decision. And that's just what gives me pause, whether it's right or wrong. It's just that there's a precedent being set here.
Ms. Russell, you're recognized.
Thank you. Completely understand that. I think the difference there is that the court cases did not apply universally. So in an effort to not have every property owner have to file suit to get a property assessment, we feel that the clarifying legislation is needed. And I do think, speaking of precedent, it's important to note that every other state in the country assesses timeshares as residential. So we, as Tennesseans, don't want to set a precedent otherwise. There is a caveat to that. The state of Missouri implies that they're residential, but if they're rented out, they'll be commercially. But it's important for Tennessee to not move to the only state in the country that would be commercial on these.
Thank you. Any other questions? Hearing none, we'll go back into session. Thank you. Chairman Todd, you're recognized.
And I appreciate that clarification that, again, we had property assessors that are on this board that know the law. They practice it for a long time and felt like that the practice and the manual says it's residential. And we even had a Chancery Court uphold that. And I'm sure there are technicalities that went beyond that, but we do need this clarified in state law. And that's what I'm bringing it for, because this isn't universal. It's pick and choose which one you're going to charge commercial. And we need a standard. And I think this is the right standard to keep. I mean, most timeshare owners have an annual income of a little over $80,000. We're not talking about super wealthy people or anything. These are just average folks that decide to go this route for their families. And you all know, many of you may be timeshare owners, but there are many folks in society that go this route for their families. And we just want to protect that and not end up costing them an arm and a leg just because some local governments decide to change what the practice has been for 30 years.
Is there any other questions? Chair Lady Littleton, you're recognized. We're on the amendment.
Thank you, Mr. Chairman. How did they decide just Davidson and Sevier County? Did I miss that somewhere?
Chairman Todd.
As far as what I'm trying to think of the counties I'm familiar with that have timeshare properties in them, Davidson, I think the Crossville area, I think Cumberland County has some, and then Sevier County. And I don't know of any others right offhand. There could be some. So this would obviously apply statewide. But those two, again, I don't know the reasoning why they decided to get just some of those properties to charge a commercial rate for. They don't even do it to all of them. So it's kind of arbitrary of what these decisions have been. And I think as subdivisions of the state, we need to be able to tell them this is the box you play in, this is the rule, and this is what you go by.
Chair Lady Littleton.
Thank you, Mr. Chairman. Because I even thought about Hamilton County because, Chattanooga, but they don't have, but this would be statewide and not just for these two counties.
Chairman Todd.
It would be statewide if any, and I could certainly see Hamilton County having some in the future, but each of these companies that build these timeshares and then sell the interest in them, they pick things that are popular, and certainly Nashville and Sevierville and the Crossville area are very popular, have been for many years. One property that I know of in Crossville has been around, I don't even know how many decades. We stay there occasionally when it's convenient. Very neat property. And again, that's not, it's all residential. It's all treated as residential, and we should treat all of them the same.
Thanks, Chair Lee.
Mhm.
Is there any other questions? Any other comments? Is there objection to the question? We're voting on Amendment 4729. All in favor, say aye. Aye. Opposed, say no. No. Heard 2 ayes and 2 ayes.
Butler?
The ayes prevail. We're back on the bill, House Bill 889 as amended. Any other questions? Any other comments? So objection to the question. Hearing none, we're voting on House Bill 889 as amended. Madam Clerk, open the voting board. Members, cast your vote. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 3 ayes and 2 noes.
The ayes prevail. House Bill 889 as amended moves to next available calendar of state and local government. Item 18, House Bill 2446 by Chairman Hicks. Is there a motion? We have a motion and a second. Chairman Hicks, you're recognized on House Bill 2446.
Thank you, Mr. Chairman and committee. This is an issue that was brought to me first by my volunteer fire departments when they looked at the community grants that we provide, 25 million. And the problem that they had was they can't purchase vehicles with this grant. And so that's what this would do. This would just remove that prohibition on trucks, vehicles.
You've heard the explanation of the bill or questions of the sponsor. Chairman Crawford, you're recognized.
Yeah, thank you, Mr. Chairman. And Chairman Hicks, did you say trucks? It only affects trucks or cars and trucks?
Vehicles. Let me go with vehicles.
Okay. All right. I was a little confused, so thank you.
Any other questions for the sponsor? The members ready for the question? Is there objection to the question? Madam Clerk, open the voting board. We're voting on House Bill 2446. Members, please cast your vote. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 7 ayes and 0 noes.
The ayes prevail. House Bill 2446 moves to the next available calendar, state and local government.
Thank you, Mr. Chairman. Committee.
Item number 20, House Bill 1827 by Chairman Hicks. Is there a motion? We have a motion and a second. You're recognized on House Bill 1827. Do you have an amendment?
Yes, sir, I do. Drafting code 015633.
Is there a motion on the amendment? We have a motion and a second on Amendment 15663.
633.
633. Thank you very much for your help, Mr. Chairman. If you'll go ahead and explain your amendment.
All right, the amendment actually makes the bill, Mr. Chairman. And what it does, so this bill as amended establishes a notification and hearing process in counties without zoning for crypto mining operations and nuisance quarries. Many communities have seen impacts from noise, heat, or dust from operators who have not taken adequate steps to establish a buffer between their operations and existing homes. As amended, the bill sets up a process for local government bodies to review the quality of proposed facilities. The bill contains a list of requirements that operators would need to submit in order to receive approval. The list of requirements are all items that quality operators are already doing to act as good neighbors in our communities. And with that, Mr. Chairman, I stand to answer any questions.
Okay, is there questions on the amendment? Hearing none, members ready for the question. We're voting on Amendment 15633. All in favor say aye. Aye. Opposed say no. The ayes prevail. We're back on House Bill 1827 as amended. Is there any other questions for the sponsor? Is there objection to the question? Representative Mitchell, you're recognized on the amended bill.
Yeah, thank you, Mr. Chairman. Yeah, Mr. Chairman, I've heard some concerns about the quarry part of it. You know, I think it may need some more work. Are you okay to work on that in full?
Hicks.
Yes, sir. I've been trying to work on that. We've already been working with all stakeholders to make sure that we can try to get this where, not that everybody will be happy, but that everybody will be equally upset. That's what I'm working on. And so far, so good.
Representative Mitchell.
I'm good.
Is there any other questions? Any other comments? Is there objection to the question? Hearing none, seeing none, we're voting on House Bill 1827 as amended. Madam Clerk, open the voting board. Members, please cast their vote. Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 5 ayes, 1 no, and 1 present not voting.
The ayes prevail. House Bill 1827 moves to the next available calendar, state and local government.
Thank you, Committee and Chair.
We took it up and voted on it. We voted on it. Okay, the next item on our agenda, on our calendar is item 21 by Chairman Vaughn. We'll be in order, please. I know we're getting tired, but Chairman Vaughn, you're recognized on House Bill 2386.
Thank you, Mr. Speaker, Mr. Chairman, foretelling great things for you there, Mr. Chairman. If you wouldn't mind, we've got a little bit of cleanup to do on that bill. If we could roll that for 1 week, we would love to do so.
This is the final calendar, and we shall complete the calendar probably today.
You know what? I'll deal with that fiscal note prior to the next stop if I receive favor today. How about that? I'll present the bill then.
You have the floor, and you have no amendments.
No, sir.
So you're recognized on House Bill 2386.
What this bill proposes, Mr. Chairman and committee, and this is already done in many places throughout the state, is whenever a developer brings utilities to an area that may come past, or I'll tell you, a subdivision that's 3 miles from the nearest sewer interceptor and a sewer pipe is laid to get to that sewer. This requires that the local community provide some type of cost recovery when that system is a part of their public utilities. And so that gives a cost recovery opportunity for a private developer who's investing in public infrastructure. And that's the purpose of the bill.
You've heard the explanation. Is there questions, comments? Is there objection to the question? Hearing none, seeing none, Madam Clerk, open the voting board. We're voting on House Bill 2386, moving to the next available calendar, state and local government. As members cast your vote. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 5 ayes and 1 no.
The ayes prevail. House Bill 2386 moves to the next available calendar, state and local government. Item 22 on the Vaughn calendar is House Bill 2587. Is there a motion? Is there a motion and a second? We have a motion and a second. Chairman Vaughn, you're recognized on.
Mr. Chairman.
Yes, Vice Chairman Wright.
Thank you, Mr. Chairman. As I peruse my state-offered iPad, I find Senate Bill 2322 assigned to the General Subcommittee.
Without objection, this bill will be rolled to the hill. Hearing no objection, House Bill 25.
I can do one better, Mr. Chairman. I can take it off notice.
Without objection, House Bill 2587 is off notice. What brings us to item 23, House Bill 2592 by Chairman Vaughn. You're recognized.
Thank you, Mr. Chairman and committee. What 2592 is trying to do.
And you do have an amendment.
Yes, sir, I do have an amendment. It makes the bill, it's Amendment 015025.
We have a motion and a second on Amendment 15025. You're recognized on the amendment.
Thank you, Mr. Chairman. And what we're trying to do here is there are utilities across, power utilities across our state have designated territories. They sometimes come from the way the electric system was built out at the time. But given the fact that municipal systems are owned by the taxpayer of a certain municipality, co-ops are owned by members. The people who find themselves receiving power from a municipality that does not live within its corporate boundaries have no representation with regards to governance with the board. What this bill, well, let me go further. In addition to that, whenever territory that's not within a corporate boundaries is annexed by a municipality, in our Tennessee statutes, we have a valuation process by which those assets are transferred from ownership of the co-op system to the municipality. So we already have in code a way that this process works. What this bill would do, and what we find, or we have the potential to find, and in some places I see it across our state, is that political jurisdictions are using access to utilities to control land use policies in areas that are not within their own corporate boundaries, because they either slow roll the extension of utility or upgrade with regards to it. And in, I think here lately, I think you saw with areas of Williamson County that gets, and Wilson County that receive power from NES, they had no redress with regards to the level of service and level of acceptable service of what they found during the ice storm. And so this bill may not do a thing with regards to creating any type of transactional business throughout the state. But if you can't say no to somebody, then you are not negotiating and you have zero leverage when it comes to improving your service. What practical reason would a municipal system have for providing better service to someone that doesn't vote for the people that own them? I'll give you a prime example. In Memphis, and Memphis Light, Gas and Water tried to expand their board of their operating board to accept two non-voting members who are from outside the corporate boundaries into a voting membership role, basically give them a full membership on the board. The Memphis City Council rejected that and said, no, we are not going to take customers of the utility into consideration whenever we're dealing with policies with them. And so with this provides an opportunity if a government subdivision is receiving services from another government subdivision outside of their corporate boundaries, they have an opportunity to present a request, much the same way that they do with co-ops, to evaluate the system, and then they have an opportunity to decide whether or not there's the political will in their community to make that purchase. This isn't an asset grab. This isn't an asset forfeiture. It's using the same system that you within that business right now and flipping it so that hopefully customers can have some form of redress that they do not currently have today. And I would think that if nothing else, just the pressure of knowing that someone has an option may result in them receiving better services from the people that they receive the power from now. And I realize this is not just a Nashville or Memphis issue. There's other situations where it comes into play around the state. And that's what the bill does, Mr. Chairman.
Thank you, Chairman Bond. This time we do have a speaker, so please come forward. And we will go out of session. Mr. Elrod, if you please have a seat and identify yourself and who you represent. We will go out of session. You're recognized for 3 minutes.
Thank
Thank you, Mr. Chairman, members of the committee. My name is Jeremy Elrod. I'm with the Tennessee Municipal Electric Power Association. We represent the state's 60 municipal and county electric utilities, which collectively they serve over 2/3 of the Tennesseans with 2.5 million meters across their systems, varying in size from 2,000 customers to 460,000 customers. We appreciate Chairman Vaughn and his willingness over the years to work with utilities, but on this bill, we respectfully disagree. As Chairman Vaughn mentioned, this bill allows a city or county served by another city's electric utility to either purchase the electric system in their limits or allow an electric cooperative to purchase it. The bill's valuation formula is similar to the one in statute, as Chairman Vaughn mentioned, when a city's electric system buys electric customers or electric cooperative customers in an annexed area. But a significant difference that's in this bill is that it subtracts from that valuation any infrastructure given to the utility for costs and aid of construction with no time limit on how far back that goes. The bill also deleted, as Chairman Vaughn mentioned, the statute that allows municipal electric customers to buy those electric cooperative customers when they annex an area, which for a city that allows them to serve all of their residents within their city limits. This bill does apply statewide, as Chairman Vaughn mentioned, and it has far-reaching consequences. First, it makes making portions of an electric system available for sale at virtually any time threatens utility financials and operations. Customers in both the area being sold and those remaining with the system could face higher electric rates. Bond ratings could be affected. Bond covenants jeopardized. Long-term planning complicated. And investing in reliable service could be undermined. Second, the bill overrides 80 years of legal and regulatory safeguards. It preempts longstanding referendum requirements that are in both state law and many city charters, and it doesn't reference or take into account the TVA regulatory process and oversight of mergers and acquisitions. These different safeguards provide transparency, financial review, accountability, but are not addressed in the bill. Third, the bill treats municipal and cooperative electric utilities differently. Cities and counties served by a municipal electric utility can buy their electric system serving them, but cities and counties that are served by an electric cooperative cannot buy their system. Municipal utilities are public entities with open records and public meetings requirements, allowing customers to get figures and information and address the board. Cooperatives are private entities with no requirements for open records or public meetings or sharing information. Several years ago, a city in Middle Tennessee tried to buy its electric system from a cooperative, but the cooperative and the courts blocked it. If legislation is to allow cities and counties to buy their electric system, it should apply equally, regardless of whether served by a municipal or cooperative.
Mr. Elrod, your time's expired. Thank you very much for your
Thank you,
testimony. While we're out of session, is there any questions for Mr. Elrod? Yes, Representative Butler.
Thank you, Mr. Chairman. So I want to make sure I'm understanding. Right now, if a municipality annexes a portion of a county and they have a cooperative there, then right now the municipality can buy those customers basically from the cooperative. Is that correct?
Mr. Elrod.
Yes, sir, that's correct. It's according to formulas and statute. That's according to evaluation of the property. And not to get into the details too much, but it's similar to what's in the bill, essentially 10 years of revenue, of expected revenue from those customers.
Representative Butler.
Thank you, Mr. Chairman. So as I understand what the sponsor is trying to do, he's trying to reciprocate that to go the other way. Why would that not be the fair way to do things?
Mr. Elrod.
Well, the customers, they're not being annexed into the city. They're already established members of the utility. So it's for the annexation part statute. That's when a city annexes territory, and it's to allow a city to serve all of its residents. Is the purpose of that statute.
Representative Butler.
Thank you, Mr. Chairman. But the way I understand what's in statute now, if the city goes out and annexes the cooperative, they are essentially taking those customers away from it because they annexed them in. It's not because those people wanted it. It's because they were annexed in and forced to go to that municipality. Is that not correct?
Well,
Mr. Elrod.
Sorry, Mr. Chairman. Well, it's my understanding annexation has been severely curtailed because of the requirement for referendums and that kind of thing. So it's been my understanding that they usually want to go into this to become part of a city. And if I'm incorrect, please let me know.
Representative Butler.
Well, the question's not annexation. What's currently in statute forces those folks that are on the cooperative to be now, they have to be served by the municipality based on what you just stated that's in statute now. And so what this bill seeks to do, as I understand it, I'm trying to make sure I'm not missing something, is just asking for that to be reciprocated.
Mr. Elrod.
Well, we would argue that the bill, I guess, goes too far the other way. And by taking it away from cities, allowing them to buy those customers in the annex area, one. And then second, if a city wants to, a city or county, if they're served by a municipal, they can buy those customers, or they can assign that ability to buy those customers to an electric cooperative. So the municipal then does not get a say whatsoever in it. Now they get money from that sale. The bill does not go to where the money can go. It could go to the city's general fund. We would like for it to remain with the utility system, but it does not do that. It could go to the city's general fund potentially.
Representative Butler.
One follow-up. Thank you, Mr. Chairman. So, the kind of way I look at it is, let's be fair. If, and the situation that's currently in statute, a municipality basically can go in, annex a tract of land, 1,000 customers, whatever it may be. And those customers really have no say, no choice, no vote, no nothing. They are automatically forced to change over to the municipality instead of the cooperative. And so there's no choice in this. In this situation, those customers would have the option to go to a cooperative from a municipality. Why would we not want that street to be flowing both directions?
Mr. Elrod.
I would say with the referendum requirement, that would be something they could take into consideration of whether or not, that would be something that they would be aware of, that they could potentially be made customers of the municipal electric utility. But I think also if, the customers under this bill are not making the decision, the elected leaders of the city are. And if those elected, or the county as well, but if those the elected leadership of the city and county wanted to do it, this applies to if they're served by a municipal or county electric system and not cooperatives. And because board members for electric cooperatives are elected to serve an area, they may be voted upon by other folks outside of that district or that area, but they don't report to the city. They just are elected on their own and serve separately, separate from the city. But the city does not have a say either on, and that's something that, we have against, one of the reasons why we do not support the bill is because it's not reciprocated between the types of utility. It only applies to municipal electric utilities when it's for cities to buy their electric system.
Thank you, Mr. Elrod. Thank you.
Thank
We'll
you,
go
Chair.
back into session. Chairman Crawford, you're recognized.
Move previous question.
Sir, is there objection? Hearing no objection, we're voting on House Bill. No, we're voting on Amendment 15025. We're going to put it on the board. Madam Clerk, open the voting board. We're voting on the amendment. All members, please cast their vote. So every member voted. Does any member wish to change your vote? Madam Clerk, take the vote.
Mr. Chairman, you have 5 ayes and 2 noes.
The ayes prevail. We're back on the bill 2592 as amended. Representative Mitchell recognized.
Yeah, thank you, Mr. Chairman. So, the main reason I think in Davidson County, surrounding counties are part of, we supply water, we supply sewer, we're supplying electricity, is just the surrounding areas were incapable of doing it themselves. So these customers now would not have access to water and sewer, electricity, or whatever in these areas. They knew where they were buying or building a home was part of the NES system or Metro Water or whatever. Metro put out the risk, the bonding to extend these systems, And now we're just going to like, once we, I'm just know about Metro. I don't know, your co-ops across the state are going to be affected by this as well. I mean, so we're going to have somebody just come in and they can take it over because, they didn't have the wherewithal to provide services to their constituents. And, they should be happy and thankful that, that Metro provided services to their constituents. But we don't seem to be too thankful these days.
Asked if you'd like to respond.
Mr. Chairman, and to my friend from Davidson County, the development of the electric system across the Tennessee Valley was something that was a access it where you can, and that pole may be closer. But what we've seen now is that the governance of this does not match the customer base. We give these monopolies a chance to operate. What we're saying is that if someone doesn't want to be under that monopoly, that they have a right to go to somewhere where they at least can vote for representation for the board. And right now, the municipals are not allowing that. And so I don't know if a single transfer of a single customer will occur from this, but I do know that customers will have the leverage of being able to tell somebody, you can't mistreat us forever. We want to get things fixed right, and we have an out if it's available to us.
Follow up, Representative Mitchell.
Yeah. I've said for a long time, City of Nashville keeps getting attacked by the state. And I've told several mayors this, that water and that sewer line that we've paid for going into these other counties, we can turn that tap and maybe some of this abuse of Nashville would end. When that water stops flowing and that commode stops flushing, you'll leave Nashville alone.
Vice Chairman Wright, you recognize.
Thank you, Mr. Chairman. Move previous question.
Previous question. Is there a second? We have a motion and a second. Is there objection to the question? Hearing none, we're voting on House Bill 2592 as amended. Madam Clerk, open the voting board. Members, please vote. So every member voted. Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 4 ayes and 3 noes.
The ayes prevail. House Bill 2592 as amended moves to the next available calendar, state and local government.
Thank you, Mr. Chairman and Subcommittee.
Item 25, House Bill 2478 by Representative Parkinson. Is there a motion? Is there a second? There's a motion and a second. Representative Parkinson, you're recognized on House Bill 2478. I believe you have an untimely amendment. Is that correct?
Yes, sir, I do. And I would.
What is the amendment, the barcode on the untimely filed amendment?
I have 016050.
16050. Is there a motion to consider? There's a motion and a second to consider the untimely. All in favor say aye. Opposed say no. The ayes prevail. We'll now, is there a motion on the amendment 16050? We have a motion and a second on the amendment. You're recognized on the amendment.
Thank you, Mr. Chair. This is just a quick change. And it just simply changes driver's licenses to thumbprints. And I can explain more if allowed to explain the bill.
That's the only change the amendment makes?
That's what it makes, yes, sir.
Is there objection to the question? We're voting on amendment 16050. All in favor say aye. Opposed say no. The ayes prevail. The amendment, you're now recognized on House Bill 2478 as amended.
Thank you, Mr. Chair, and to the committee, thank you for allowing me to present the untimely filed amendment. And thank you, Mr. Chair, for the discussion about the amendment this morning. I appreciate you. In Tennessee, between 2019 and 2024, 185 dwellings in 50 Tennessee counties were stolen. Nobody is off limits to these property thieves. Even Graceland, there was an attempted theft of Graceland. Last year, in 2024, there was a lady named Janine Finley. She used a fake entity called Nitty Investments and false signatures to claim that Lisa Marie Presley had pledged Graceland as collateral for a loan that went unpaid. A fraudulent foreclosure notice was published in the Memphis newspaper attempting to force an auction on the property. Federal investigators identified that the signatures were forged, including those of a Florida notary who had never met Lisa Marie Presley. The auction was blocked in May of 2024, and in September of 2025, Ms. Finley was sentenced to over 4 years in federal prison for the scheme. The Graceland case highlights the dangers of home title fraud, particularly for high value or well-known properties, and emphasize the need for legislative changes. But what about 84-year-old mother, grandmother, and widowed senior Cornelius Bolden? She lives alone, and another bad actor attempted to fraudulently sell contracts on her home. He was being successful selling these contracts.
Mr. Sponsor, we do have a good fix now in the context. Could
Yes,
you
sir.
please tell us what your bill will do to cure this?
Yes, sir.
Thank you.
What this bill does is it allows for a 2-year pilot for Shelby County Register of Deeds only to require a thumbprint for walk-in customers that want to do a property transfer via quitclaim. That's what the bill does.
Members, you've heard the explanation. You have questions for the sponsor? We're voting on the amendment. Well, no, the amendment is on the bill. Excuse me. Is there objection to the question? Hearing none, we're voting on House Bill 2478 as amended. Madam Clerk, open the voting rolls. Members, please cast your vote. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 3 ayes and 4 noes.
Then the noes prevail. House Bill 2478 amendment as amended does not move forward.
Thank you, Mr. Chair. Thank you, Committee.
We will now take up item 26, House Bill 2418 by Representative Boyd. We have a motion and a second. Representative Boyd, you're recognized, and I believe you have an amendment.
Thank you, Mr. Chairman. I do. That's Amendment Drafting Code 015624.
We have a motion, and we have a motion and a second on Amendment 15624. You're recognized on the amendment.
Thank you, Mr. Chairman. Do you want to go ahead and put that on there that I can explain
Well,
the
go
bill?
ahead and explain the amendment.
Okay, yes,
and
sir.
then we'll do business.
Thank you, Mr. Chairman. And first of all, it's an honor to be before such an esteemed group of lawmakers.
Please be on the bill, sir, on the bill.
The amendment makes the bill. What the amendment does, and for many years as lawmakers, we have heard from ratepayers across the state who have complained, those people that buy their electricity from municipally owned local power companies, if they live in an unincorporated part of the county outside of the city limits or in a neighboring county, unlike their brethren that buy water or natural gas from the city, they can't go to TBOR if they have a grievance. They have no city councilor, they have no one representing them on the board, and they don't get to vote for the mayor of that city. So what this bill would do, what the amendment would do, Mr. Chairman, is it would give a voice to those ratepayers who essentially have no choice but to buy their electricity from the person or the entity that provides it in that area, a municipal local power company. It would give them a seat on the board of directors. So if you are in an unincorporated portion of the county outside the city or a neighboring county, if there are more than 500 or more ratepayers in that county, the county mayor would be able to appoint someone to the power board. Now, we've established that de minimis number of 500. We've also put it in there where it is permissive for the county mayor. In the event that there is a county mayor that doesn't want a board member on the board, they don't have to take action on that. They can leave that position vacant. This does not apply to city council governed municipal utilities. So if they don't have a power board and they're governed by the city council, this bill would not apply to them. Neither would it apply to multi-jurisdictional energy authorities. Mr. Chairman, I would doubt that anybody would have any questions as thoroughly as I've explained this amendment, but I'll take any if they do.
Thank you, Chairman Boyd. At this time, Whip Boyd, excuse me. We will go out of session. We do have a speaker. Mr. Elrod is coming forward to speak. So we'll go out of session. Mr. Elrod, if you'll give your name for the record, and you will have 3 minutes, sir.
Thank you, Mr. Chairman, committee members. My name is Jeremy Elrod. I'm with the Tennessee Municipal Electric Power Association, as I stated earlier. First, as Whip Boyd mentioned, in its current form, the bill requires many municipal and county electric utilities to add board members from counties outside their home or host county if the utility has at least 500 customers in that county. Now, this legislation I know has been mentioned a lot with NES, but it does apply statewide and would have implications for dozens of municipal and county electric utilities. And seeking to increase customer representation, this bill creates severely disproportionate representation on many boards. For example, National Electric Services Board would have a majority of board members representing less than 13% of its total customers. Many other utilities will see a disproportionate share of their customers being overrepresented on utility boards, meaning a disproportionately large number of board members would represent a very small minority of customers. Utility boards oversee rates, long-term infrastructure planning, system reliability, financials, and debt. A board with extreme disproportionate customer representation could disrupt bond ratings, complicate compliance with bond covenants, affect rate-making decisions, and undermine system investments. These risks extend beyond utility governance with real financial and operational consequences for electric reliability and affordability. The legislation was filed after Winter Storm Fern, an historic storm with historic effects on several utilities across Tennessee, North Mississippi. Nashville Electric, one of the largest utilities of the state, took 14 days to get customers back on, or took 14 days to get power back on to 230,000 customers. Two smaller cooperatives in West Tennessee took 16 days to get power fully restored to all of its customers, and 5 utilities in Mississippi even longer. We ask that we keep that in mind. We ask that you keep that in mind as this goes forward. With 60 municipal and county electric utilities in the state, there are 60 unique situations as to where, how, and who they serve. To close, we support proportional representation, but not overrepresentation. We appreciate Whip Board bringing this bill, and we're committed to work with him to expand customer representation on utility boards in a proportional and balanced manner and get this right if it moves forward. Thank you, Mr. Chairman.
Thank you, Mr. Elrod. We'll go back into session. Any other questions for the sponsor? Chair Lady Littleton, you're recognized.
Thank you, Mr. Chairman. Of course, I live in Dixon, and we have Dixon Electric, and it serves 7 counties. So how will this affect the Dixon County system?
Whip Boyd.
Thank you, Mr. Chairman. So Dixon Electric System, there are some counties that would get representation on there, some that would not. Based on the data that I was given by Mr. Elrod, I'm seeing Cheatham County would have one, Hickman County would have one, Montgomery would not, Houston would not, Williamson would not, Humphreys would not. So it would basically, you would have Cheatham, Hickman. I'm sorry, Cheatham is that is where Dixon is, isn't it? Yeah. No, that's what county is it in?
Cheatham
Dixon
County.
Okay,
I'm
so
talking
Cheatham.
about Dixon County.
Yeah, okay, I'm sorry. So Cheatham would have one, Hickman would have one, and that would be it.
So we'd
based
add
on the
2
Madam
more.
Chair Lady Littleton.
I'm sorry. Okay. And how would they have like full responsibility on like the other board members, or would they kind of be part
Whip-
them? Would
Whip
they have the
Boyd,
full
I think, ex officio members, or would they be
that's it.
full voting members?
Thank you, Mr. Chairman. They would be full voting members.
Chair Lady Littleton.
Okay, thank you.
Representative Dixie, you're recognized on.
Thank you, Mr. Chair. I just kind of wanted to bring to the committee's attention again, it's just a pattern of what's going on. We just voted on a bill not too long ago that decreased our revenue for Davidson County. Now, this one is going to increase some expenditures. And I said, we're chipping away at the pocketbook of the state. And I would hope that we would start to look at these things from a financial manner as opposed to emotional, or because obviously there was no problem until we had this one issue. We learned from it. But out of, 80 years, I think that's what the previous speaker told us. We've never had any issues. And I feel like we're just coming down with a sledgehammer to put a nail in. So I would just caution us to think about the financial impact that these bills are having. Please look at the fiscal notes. They do have an impact on us. And if you keep doing it over and over and over, there's not going to be much money left over to pay for your police or your fire, your schools, because we're the one footing the bill in Davidson County. But thank you, sir.
Representative Mitchell, you're recognized.
Yeah, thank you. And I'm glad Mr. Elrod brought to the attention, we're going to have possibly five new board members to NES to go with our current 5. But the new 5 will be representing a fraction of the ratepayers, and 90% of the ratepayers will be represented by 5 people, and 10% of the ratepayers will be represented by 5 people. We're going overboard here. 3/4 of an inch of ice is not an everyday occurrence. A hurricane in East Tennessee that washes away a hospital in a floodplain is not an everyday occurrence. Railroad track blowing out in Waverly, Tennessee from a flood where people were told that was a risk is not an everyday occurrence. But only in one of those 3 scenarios, we offered a helping hand in 2 of those scenarios. We're coming in here with a baseball bat on the other one. We want to always, whatever we can do to harm Nashville, let's try to do it. But, the representation from Davidson County, when we saw our colleagues in East Tennessee needed help, we were right there to help. When we saw our friends in Middle Tennessee and in Humphreys County needed help, I took a crew of legislators to Waverly to go down there and help. We took 3 pickup trucks we picked up from supplies from Home Depot and donated to them. But now everyone seems to be jumping on the bandwagon when Nashville had a natural disaster. We want to see what other harm we can do to Nashville. Again, what's wrong with people? Get your, have a little empathy and have a little common sense.
Chairman Whip Boyd, you're recognized.
Thank you, Mr. Chairman. And both of my friends down there made a great argument for perhaps another bill, but this bill simply is not relevant to what they're talking about. This allows the ratepayer, and just to clarify, guys, municipally owned local power companies are siloed financially. The asset belongs to the city, but they in no way otherwise are supposed to be commingling funds or doing anything like that. Their sole responsibility is supposed to be the ratepayer. And an arbitrary county line it shouldn't dictate whether or not someone has representation or not, but unfortunately it does. So what this bill does, we're not asking that they become employees or that the city incur any cost. We're just simply saying give those ratepayers, those Tennesseans that live on the other side of that arbitrary line in the sand, give them some representation on the board.
Representative Mitchell, for a follow-up.
do you think it's fair for 10% of the ratepayers to have the same voice as 90%? Let's say,
Whip Boyd, you're recognized.
Thank you, Mr. Chairman. I think it's fair that 10% have a seat on the board. And I don't think it's fair that those 10% went 13 days without electricity and had no board member that they could call on, no one that they vote on that serves on that board, or any city councilor or mayor or anything for that matter. So I think it's important. I've stated my case. I don't want to take seats away from the existing board. But if you are a ratepayer and you have no representation on that board, this bill will fix that.
Follow up. Representative Mitchell.
all of us could have called any of the 5 board members. And I think if they're a ratepayer, I don't think one of the board members on the board would have said, well, I'm not talking to you because you don't live in Davidson County. Can you find any instance where that happened? You're making up scenarios that don't exist.
Whip Boyd.
I don't have anything, Mr. Chairman.
Any other questions? Any other comments? Is there objection to the question? Hearing no objection, we're voting on Amendment 15624. Madam Clerk, open the voting board. Members, will you please cast your vote? Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 3 ayes and 4 noes.
The noes prevail. House Bill 2418 as amended. No, excuse me. We're back on the bill as amended. The amendment fails. Now we're back on the bill 2418 as originally proposed.
Mr. Chairman, without an amendment, I mean, we can
take it off. Take it off.
Yeah. Okay, let's move it forward without the amendment, Mr. Chairman. I mean, the amendment changed a few things, but if we can move it to full, I've committed to working with the Tennessee Municipal Association, or the Municipal Electric Association. I'm at the will of the committee.
Representative Mitchell, you're recognized on the bill.
I move that we roll the bill to the hill of the calendar.
Is there a second to the roll of the heel? Is there, hearing no second, motion fails. Whip, you're recognized on the bill.
Mr. Chairman, I would appreciate passage to full committee.
Previous question's been moved. Is it properly seconded? Okay. Is there objection to the question? Hearing none, seeing none, we're voting on House Bill 2418, moving to the next available calendar of state and local government. Madam Clerk, open the voting board. Members, please cast your vote. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 4 ayes and 3 noes.
The ayes prevail. House Bill 2418 does move forward to the next available calendar, state and local government.
Thank you, Mr. Chairman of committee.
We are now on item number 27. Representative Leatherwood here. Without objection, we'll roll item number 27, House Bill 1779, one space. Next bill is item 28, House Bill 2521 by Representative Vidal. Is there a motion? I hear a motion. Is there a second? We have a motion and a second. Representative Vidal, you're recognized on House Bill 2521. I believe you do have an amendment.
That is correct, Mr. Chairman. Amendment 013483.
Is there a motion on the amendment? Motion. I hear a second. We have a motion and a second. Representative Vidal, you are recognized on the amendment.
Thank you, Mr. Chairman, committee members. This legislation simply aims to resolve all outstanding statutory issues raised by the FBI regarding firefighter background checks. The FBI requires specific statutory language to approve state-level, multi-state fingerprint-based background checks. The FBI recently notified the Tennessee Bureau of Investigation that current state statutes no longer meet their evolving requirements. Therefore, TBI, Tennessee Fire Service Coalition, and various firefighter groups have developed this specific language to finally meet FBI procedural standards. This bill provides fire departments with two distinct pathways for conducting personnel background checks, third-party vendors, and TBI state checks. And with that, I'm open to questions.
Members, you've heard the explanation. Representative Dixie, you're recognized on the amendment.
Thank you, Mr. Chairman. How could this not have a fiscal note if you're requiring the employers to pay for the background checks? There's a cost associated with those background checks. And how could this bill not, if it's requiring them to have them, how could this not have a fiscal note?
Representative Dixie, that's a question for fiscal review, not the sponsor. If there was a fiscal note, it would be part of the package.
Okay.
Representative Vital, I'll let you offer an explanation, but you don't.
Thank you, Mr. Chairman. I would just clarify that the TBI state checks, the departments may continue to use TBI for state level checks. So probably the cost is already there without any additional cost, or third-party vendors. The department may run checks through private third-party providers.
Representative Dixie, you good? Okay. Is there any other questions for the sponsor? Is there objection to the question? Hearing none, we're voting on the amendment 13483. Madam Clerk, open the voting board. Members, please cast your vote. We're voting on the amendment. Several members voted. Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 5 ayes and 0 noes.
The ayes prevail and the amendment 13483 moves forward. Now we're back on Bill 2521 as amended. Is there any other questions? Hearing none. Is there objection to the question? Hearing none, we're voting on House Bill 2521 as amended. Madam Clerk, open the voting board, please. Members, please cast their vote. Several members voted. Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 5 ayes and 0 noes.
The ayes prevail. House Bill 2521 as amended moves to the next available calendar, state and local government.
Thank you, Mr. Chairman. Thank you, all members.
We are now back on item 27, House Bill 1779 by Leatherwood. Without objection, House Bill 1779 is rolled to the heel. Brings us now to item 29, House Bill 2314 by Representative Fritz. Is there a motion? Is there a second? We have a motion and a second. Representative Fritz, you're recognized on House Bill 2314. I believe you have an amendment.
Yes, sir, Mr. Chairman. Thank you. Thank you all so much. Thank you for your forbearance last week to give me an opportunity to do this. And the amendment is 15641.
Is there a motion on the amendment? Is there a second? Second. We have a motion and a second on amendment number 15641. You're recognized on the amendment.
Thank you, Mr. Chairman. I'll go first to the change we made in the amendment because I heard the concerns. We did talk to the Attorney General's office, and I heard the concerns of legal regarding constitutionality, especially with the print material. So we changed that warning, and you'll see that in the amendment. It now reads, "For your information, production of these materials may contribute to an increase in domestic assault, rape, or sexual assault and human trafficking." And I would offer just a couple things to substantiate the change and why this is necessary, Mr. Chairman and committee. First and foremost, I would offer 16 Code of Federal Regulations 501 Truth in Fur Labeling Act. we have federal legislation that requires labeling so that we understand where fur product comes from to take care of the animals. Secondly, 16, Code of Federal Regulation 1501, small parts, small pieces regulation to prevent our children from choking. It applies to balloons, books, clothing, modeling clay, paints, and other things. One other example, food labeling. The FDA places nutritional values on food. Certainly, we all have that creator endowed right to eat. And on their nutrition for sugar, salt, sodium contents, and even nut allergies are often displayed on products that we consume. Social scientists, psychologists, and medical professionals have been studying the relationship between the use of sexually explicit entertainment and domestic violence, rape, and sexual assault for decades. In 2021, the National Institute of Health published a longitudinal, easy for me to say, Mr. Chairman, review of these studies and concluded, and I quote, as expected, exposure to pornography was positively associated with sexual aggression, end quote. Secondly, at least 700,000 persons, primarily women and children, are trafficked annually within and across international borders. An estimated 50,000 of these are trafficked in the United States. The sex industry and entertainment industry has expanded rapidly over the decades. It involves an exploitation of persons, primarily women and girls, and involves activities related to prostitution, pornography, sex tourism, and other commercial sexual services. And I'll close with this, Mr. Chairman. In 2024, Unbound Now, an organization dedicated to the ending of human trafficking, estimated that 40 million people are now enslaved globally in human trafficking. 79% of those are sexually exploited. This exploitation generates an estimated $6 to $15 billion annually. So I'll submit to you, colleagues, to apply these labels in these facilities is no different than the protections offered on food allergies, medical problems. I quote Johns Hopkins University, the Bloomberg School of Public Health, drug labels and black box warnings for drugs. Again, in many cases necessary to the health, but a warning label applied. And so with those, I would offer, Mr. Chairman, and thank you for your forbearance in the committee, I would ask for favorable recommendation to move this forward and answer any questions you may have.
Thank you, Ms. Sponsor. Members? Questions? Comments? Is there objection to the question? Hearing none, seeing none, we're voting on Amendment 15641. Madam Clerk, open the voting board, please. Members, please cast your vote. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 3 ayes, 1 no, and 2 present not voting.
The ayes prevail. The amendment 15641 is on the bill. We're back on House Bill 2314 as amended. Is there any other questions for the sponsor? Is there objection to the question? Hearing none, seeing none, we're voting on House Bill 2314 as amended. Madam Clerk, open the voting board. Members, please cast their vote. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 4 ayes, 2 noes, and 1 present not voting.
The ayes prevail. House Bill 2314 as amended moves to the next available calendar of state and local government.
Thank you, Chairman and committee.
Now we move to item 30, House Bill 1657 by Representative Capley. We have a motion and a second on House Bill 1657. Representative Capley, you're recognized. I believe you have an amendment, sir.
Apologize, Mr. Chairman, apologize, committee. I have been in another committee, just got done. Mr. Chairman, 10554, is that something?
No,
Have that
sir.
one? Okay.
How about 14667?
Mr. Chairman, that sounds good. That's what I have
Is there
as
a
well. Yes, sir.
motion?
I have that
We
one
have
too.
we have a motion and a second on amendment 14667. If you'll explain your amendment, sir.
Yes, sir. So let's go. What do here? Basically, Mr. Chairman, the amendment makes some revisions to the bill, so I'll just read a little bit here. But it removes the requirement that industrial, commercial, or other businesses are permitted to operate under zoning regulations or the exceptions. Immediately preceding a change in zoning may only destroy the present facilities and reconstruct new facilities necessary to the conduct of such industry or the business. Basically, Mr. Chairman, we're dealing with some zoning issues, and it's a local bill, one of my counties. Business has been there for a long time. I think my good friend's here to testify, and it's a very specific situation. And I think once he testifies, you'll understand it a little bit better than what I've just described. But
So we'll go out of session and hear from Mr. William Durham. If you'll please come forward, sir, and for the record, if you'll give your name, and you'll be recognized for 3 minutes.
Yes, my name is, thank you, Mr. Chairman. My name is William Durham. I represent Edwards Oil Company, South Tennessee Oil Company, Quick Mart convenience stores. We own and operate 39 convenience stores in southern Middle Tennessee and northern Alabama. And this bill is all about allowing successful businesses to grow and expand in certain municipalities who have certain zoning codes, or at least a fighting chance to expand. And it removes the state requirements to prove business necessity and the requirements that relate to orientation and setback from those codes. It doesn't relieve the city or municipality. They still have those codes, but there's also things that the city and counties lean on the state level that they say they can't offer variance because it's in state code. Our particular circumstance is we own and operate convenience stores. So we've been in Murray County in we have 10 locations in Murray County, 8 of which are in the corporate limits of the city of Columbia. The city of Columbia recently in 2024 passed a code where if you construct a building, you have to turn it backwards to the road and put your pumps behind it, especially in a convenience store type operation. We have every store we have in Murray County is at least 30 years old. We contribute to not only the economy there by taxes, but also to the state's economy by paying fuel taxes into the highway system. We feel it's unfair that we don't have a fighting chance to plead our case to keep our business facing forward because we have an established base of business there. A lot of our business is opportunistic, and if we turn our stores around backwards, our customers go to our competition, and then we lose revenues as a result. And that's what the basis of it is.
Thank you, sir.
Yes, sir.
Any questions? Representative Dixie, you're recognized.
Thank you. Thank you for being here.
Yes, sir.
Quick question is that the locals have already made a decision and determination on how they want to handle the situation. So your ask is for us to supersede what the locals have determined what they want in their city.
Mr. Durham.
No, sir, that's not it at all. What we're looking for is we're just asking for an amendment to Tennessee State Code. There's two particular sections. Right now, if you happen to be an existing business in one of these municipalities, you have to prove your necessity before you can rebuild. So basically, you have to prove to the courts that you'll be out of business unless you get to expand your business. So that's not our case. We're in a community that's thriving and growing. We have the properties to grow and expand our business. Matter of fact, we meet all the criteria that state code requires. We own all the property. It's been under the same ownership since 1990, and then also it's of the same use. So we meet all the other requirements. The problem is we have to deem it business necessity, which the courts have determined that that means you have to prove that you'll be out of business unless you can expand. And of course, that's not our case.
Thank you, Mr. Durham.
Yes.
Anyone else? Representative Butler, you're recognized.
Thank you, Mr. Chairman. So I'll make sure I'm understanding this. You're currently running convenience stores, and this new requirement is going to make you rebuild these gas stations. Is that what I'm understanding?
Mr. Durham.
So we have we want to rebuild it. Where our store, the particular store we're talking about, is 35 years old. It's time to rebuild that store. However, if we do rebuild that, we're on US 31 right next to the Saturn plant or the General Motors plant there. If we rebuild according to the current code, we have to turn the back of our building to US 31 and put our pumps behind the building.
Representative Butler.
That answers my question. I understand. Thank you, Mr. Chairman.
Anyone else? Thank you, Mr. Durham, for your testimony. We'll go back into session. No, excuse me. We'll go back out of session. And we do have another speaker, I believe it's Mr. Jenkins, if you'll come forward and give your name, who you represent.
Thank you, Mr. Chairman. Chad Jenkins, Tennessee Municipal League. So just quickly, I know it's been a long day. What we're talking about here is non-conforming use. So for those not familiar with that, if you are using a property and subsequent to that zoning changes, then you are allowed to continue to use that property for that use. That's preserved and protected. Really, the only way you lose it is if you abandon that property for 30 continuous months. So you are allowed under that continuing use to, if it is destroyed, storm, damage, whatever, or if you choose to rebuild, you can do it. The only requirements of if you choose to do that is that you have to, as the gentleman stated, the wording says you have to, it should have to be necessary to the conduct of such industry or business. There's no demonstration. It just, and there's no necessity. I'm not sure where the statute says it has to be necessary to conduct. So in other words, it has to be related to your business. You can't build a facility that is not related to that business. If you remove that, then you can build anything you want. It doesn't, as long as it doesn't change the commercial use. So that's a pretty significant change. It really makes a kind of a mockery of the whole grandfather and the whole protection and why it exists. So that is not a demonstration of necessity. It's just that the facility you're building has to be necessary to your business. It can't be unrelated to that. And the only other requirement is that it has to meet today's setbacks, height, physical location on it. So effectively, the only two requirements that apply to a property that is subject to conforming would be deleted and eliminated by this bill. So it would be substantial. This would be statewide in all the properties that currently enjoy this protection. So while you may find one circumstances, and I can't speak to exact on this particular one, but you're undoing all of them. That'd be great concern to us. These are local issues, be handled locally. This is a local matter. The statewide bill is there in the protection. It's administered locally, and we'd like to, so we caution you, urge you not to support this. It would really significantly harm those current.
Thank you. Representative Butler.
So let me ask a question to clarify. So they own a convenience store. They're wanting to build back a convenience store. So that's the same use.
Mm-hmm.
And the current municipal code or whatever has changed to make them build it in a different configuration. Is that what we're discussing here? I'm making sure I'm comprehending this.
Mr. Jenkins.
I can't speak to the specific situation here, sir, but what the law is, it's the requirements are the setbacks, the height, the bolt, and the location. So that's possible. That's what you have to comply with the current.
Representative Butler.
But you signed up to testify against this particular bill, but you're not sure what the bill's doing.
No, I'm saying this bill is what it
Mr.
does.
Jenkins, please.
Sorry.
No running debate. Thank you. Go ahead.
Sorry. That was about what I was saying is I can't speak to the gentleman. That was a local thing. I'm saying what the law says. So I can't speak to the specifics of that circumstance. This bill isn't just about, this bill does not only apply in this one instance. This is statewide.
Representative Butler.
But thank you, Mr. Chairman. So as I understand it, this gentleman here is asking for legislation to be changed to allow him to build back what he already is doing on that property. And the municipal code is telling him he can't do it the way he has typically built his convenience stores, is the way I understand this. And you're testifying that you don't know exactly what he's doing, but we're changing the law. I'm just not following why you're even testifying.
Mr. Jenkins.
Thank you, Mr. Chairman. The legislation before you, as I've seen it, the amendment, changes current law, which is applicable in every city and county in the state.
I understand.
And it says that if you rebuild, you may rebuild, absolutely. But if you do, you can't change. It still has to be necessary to the conduct of the business, number one. And number two, it has to conform to setbacks, height, bulk, and the physical, any requirements regarding the physical location of the structure on the site. That's what the current law says. The amendment before you deletes both of those requirements.
Representative Butler.
That's all I have. Thank you, Mr. Chairman.
While we are out of session, I'd like to turn to legal. And can you opine as to the accuracy of the statements just made?
Thank you, Mr. Chairman. Josh Houston for Legal Services. I did not find any fault with Mr. Jenkins' testimony.
Thank you. Representative Mitchell.
Yeah, Mr. Jenkins, what I think you're here testifying for is you have no idea all the non-conforming uses in Jamestown's zoning, in Dixon zoning, in Kingsport zoning, in Knoxville zoning, in Nashville zoning. So you don't know what Pandora's box we're about to open up if we pass this one piece of legislation for this one individual. Is that kind of what you're trying to tell us?
Mr. Jenkins.
I wouldn't disagree with that statement. Yes, sir. I think that's exactly right. They're all over the state, and I can't speak to any specific one to tell how.
Because you don't know what could happen.
Representative Mitchell, thank you. Any other questions for the hearing? None, we'll go back into session. Representative Capley, we're still on the amendment that makes the bill, so you're recognized.
Thank you, Mr. Chairman. And just to address a couple of things, TML would know what this bill did if they made any effort at all to come see me and talk to me about the piece of legislation, but they didn't, and that's okay. But let me redirect your attention here back to the summary and what fiscal review says, okay? Based on the information provided by CTAS, this legislation is estimated to have no significant impact on local governments. It says it right there. Any impact on local governments is estimated to be not significant. This is what's happening. They're trying to redo a business that's been there for 30 years. They're trying to reinvest in my community. They have been told, based on this little tic-tacky law, that they cannot redo that building unless they completely change the entire design, take the gas pumps out, flip it away from the road, and change the entire business. While, mind you, there are competitors surrounding this business that don't have to do that because they're not renovating their building. That's what the bill does.
Representative Dixie, you're recognized.
I would just like to reiterate, I think this is a local issue. And again, we believe in local control here. And I think this is something that they know what's best is going on in their backyard. And I don't think that we should be telling someone, a city or a municipality, what they should be doing. They know they know their requirements. They know what they want in their community. Who are we to tell them that you should do this?
Representative Capley, you're recognized.
I'm good, Mr. Chairman. Thank you.
Representative Butler.
Thank you, Mr. Chairman. I just still want to ask one question. So if they remodel this convenience store and they leave the pumps out front and they remodel the building that's in the back, would the cost not be significantly less if they leave the pumps where they are and remodel the building? I mean, it would be a fraction of the cost.
Representative Capley.
They have to flip the entire thing around.
Thank you, Mr. Chairman.
Any other questions? Any other comments? Is there objection to the question? Hearing none, we're voting on the amendment 14667. Madam Clerk, open the voting board. Members, please cast your vote. Every member voted that desires to vote. Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 3 ayes, 2 noes, and 1 present not
The ayes
voting.
prevail. The amendment is on the bill. We're back on the bill as amended. Is there any other questions or comments? Is there objection to the question? Hearing none, seeing none. Madam Clerk, open the voting board. We're voting on House Bill 1657 as amended, moving forward to the next available calendar, state and local government. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 3 ayes, 2 noes, and 2 present not voting.
The ayes prevail. House Bill 1657 as amended moves forward to the next available calendar, state and local government. Let's see, did we? Pardon me? No. Capley, Hawk. Next item on the calendar is item 31, House Bill 2160 by Butler. Do we have a motion? We have a motion and a second. Representative Butler, you're recognized. I believe you do have an amendment. 14887.
That is correct, Mr. Chairman.
We have a motion by Chair Lady Littleton. Is there a second? Do I hear a second?
Second. Member of the committee.
We have a motion and a second. You're recognized on the amendment. I'll give you a second.
Thank you, Mr. Chairman. This piece of legislation was originally drafted to be a local bill, and it was determined by legal that it needed to go through the bill process. So it's very narrowly tailored to address what was asked for by my local Overton County Commission. And it allows the Director of Accounts and Budgets to be supervised by the County Commission, which is done in a couple of other counties in the state, Rutherford County being one of those. And with that, Mr. Chairman, I'll be glad to answer any questions.
You've heard the explanation of the amendment. This is a local item, a local problem, and we're passing a bill for statewide application. Is that correct?
Mr. Chairman, if I may address that, this is tailored to address counties with a population between 22,500 and 22,600, according to the 2020 census.
Thank you for the clarification. Representative Dixie, you're recognized.
I want to make sure this is a local bill. We just voted against local control, but now we're for it. So are we for local control or are we not for local control? I'm confused.
If
Thank you, Representative Dixie. Representative Butler, this does require a ratification by the local body by what? By majority, by 2/3?
by majority, then Mr. Chairman, thank you for that.
I believe it's 2/3.
It is 2/3. I stand corrected. But I do want to address my colleague down there. I had a resolution brought to me by my county commission requesting this to be done. So the locals ask us to do this.
Very good. We are on the amendment. Chair Lady Littleton.
Thank you, Mr. Chairman, but how many, it's not just for Overton County, it's for a population, is that correct?
Representative Butler.
Thank you, Mr. Chairman. That would be correct. It would affect counties that fall in the category of 22,500 to 22,600, according to the 2020 census.
Do you know how many counties we're talking about?
I do not know that how many counties fall specifically under that number. I'm going to suggest that it's very small and most likely one.
Without objection, we'll go out of session. Legal, you're recognized.
Thank you, Mr. Chairman. Josh Houston, Legal Services. Yes, this would only apply to Overton County. The population falls between that, and that is the only county that has that population
Is there any?
under the 2020 federal census.
Okay, any other questions for legal? Hearing none, we're going back into session. Representative Butler, you're recognized.
Thank you, Mr. Chairman. I appreciate legal clarifying that. With that, I would ask for passage of this legislation.
Representative Dixie, you're recognized.
I just want to be clear. Now, this says this prohibits the termination of the Director of Accounts and Budget. It will just have to go to the legislative body. Who has that authority now? The mayor or?
Representative Butler.
Thank you, Mr. Chairman. The county mayor currently does.
So, okay. So
Representative Dixie.
Thank you.
Is there objection? Is there any other questions or comments? Is there objection to the question? We're voting on amendment. One, 4, 8, 8, 7. Madam Clerk, open the voting board. Members, please cast your vote. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 7 ayes and 0 noes.
The ayes prevail. The amendment is on the bill. We're back on House Bill 2160 as amended. Is there any other questions or comments? We're voting on House Bill 2160 as amended. Madam Clerk, open the voting board, please. Members, please cast your vote. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 7 ayes and 0 noes.
The ayes prevail. House Bill 2160 moves, as amended, moves to the next available counter state and local government.
Thank you, Committee
Now for
Chairman.
the item that we have all been waiting for. Item 32. House Bill 2366 by Chairman Hawk. You have a motion. You have a second. We have a motion to second. And I believe we have an untimely amendment. Is that correct, Chairman Hawk?
Chairman, we have amendment drafting code 014107. It's in the, on the dashboard as well as the fiscal note for that.
And it's untimely. So Chair will stand for a motion to consider an untimely amendment. We have a motion. Do we have a second? We have a motion and a second. All in favor of the motion to take up?
It's not the dashboard. We have not seen the amendment.
We will. You have a copy of the amendment? I saw it on dashboard, so. We have a motion and a second before us to consider an untimely amendment. You're recognized on the motion for the untimely amendment. Representative Mitchell.
Yes, sir, Mr. Chair. I would request a 15-minute recess so we can have time to look at the amendment and the implications of the amendment to my district and my county.
Without objection, without objection. We have an objection. Do we have a motion? Do we have a motion to recess for 10 minutes?
Motion. Second.
We have a motion and a second.
Object.
No, we have a motion we have a motion and a second to recess for 10 minutes. Is there? We'll put it on the board. Motion to recess for 10 minutes. All in favor of the motion, vote aye. Opposed, vote no. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 3 ayes and 4 noes.
The motion recess fails. Representative Mitchell, you're recognized.
Yeah, thanks, Chairman. So, earlier we sent a blank check, a caption bill to full committee. Now we're about to vote on another significant piece of legislation that affects our county, our people, and the amendment's not on our system, not on our legislative system. We've just been handed this multi-page amendment, and we're supposed to be able to vote and discuss what we've just been handed.
Representative, I've just been shown a dashboard. It's there. It's there.
Yeah.
Well, the research analyst tells me
Yeah, it's just come up.
All right. Without objection, we'll recess for 5 minutes. Is there objection? Hearing no objection, we're recessed for 5 minutes. We are now back in session. And Representative Hawk, you're recognized. We have not voted, we have voted on considering the untimely, and we're on the amendment now. Do we have a motion and a second on the amendment? We have a motion and a second on the amendment. It is properly before us. You're recognized on the amendment 14107.
Yes, Mr. Chairman and members, and thank you very much for your indulgence. I know it's been a long day, and I'm asking for a complimentary seat on this committee. Since I've been here for 2.5 hours, I would love to be named to this committee. Qualified, thank you very much. I'll go ahead and explain the amendment, which will make the bill in its final form. The amendment to the bill will help protect jobs, local businesses in the tourism hotspots of our states by making sure that local government does not choke off economic activity, which keeps Tennessee's top destinations open, clean, and thriving. Local governments should not be able to shut down or block streets and hurt businesses inside our tourism development zones. Delivery drivers, taxis, ride shares must still be able to operate and serve their customers. Streets should only be blocked for emergencies or approved events. So essentially what this bill does, it's going to add that the Tennessee Highway Patrol, in concurrence with what we said, may assist local law enforcement to help police the tourism development zones in our state. Conclusion, this bill helps local businesses in our state by ensuring that streets are not blocked and deliveries and drop-offs can be made without interference from local governments. That's what the amendment will do, Chairman and members.
Thank you, Chairman Hawk. Is there questions? Representative Dixie, you're recognized on the amendment.
I guess my question is in Bill Street, and then after a certain time, downtown on Broadway, they actually close off those the streets so that it becomes walkable. How would this bill impact that, especially if Bill Street's already set up where it's it's not set up for traffic, it's for walking traffic only.
Pedestrian.
And then Davidson, and then down here in Broadway, they do it just at certain times to make it okay so cars aren't. It makes it safer for people for walking traffic.
Chairman Hawk.
Thank you. The information that's been shared with me, local governments may temporarily permit situations like you've just said. And I know my visiting down here on Broadway to bowl games and to concerts, that the same situation can happen here. So with the event permits, those things can happen on a temporary basis as well. That does not change any of this.
Representative Dixie.
So currently, they do it on the weekends because Friday's a heavily, Thursday through Sunday is a heavy traffic event when it comes to pedestrian traffic. So that means they would have to get a permit for every weekend. That would be cumbersome just for Davidson County. I can't speak for other places, but that would be very cumbersome. And right now, that's just the way the traffic flows. I understand your premise of the bill, but I think that would be a detriment to what we already are setting up here in Davidson County, and then having to get a permit every weekend to do this. I don't see how that's feasible for a local government. And then who would they get the permit from, and who's the person that that approves the permit? I mean, it's just a lot of questions there.
Yeah.
Chairman Hall.
And I don't want to make the issue smaller than what it is, but I think that's already happening on a regular basis if they do close the streets at these points in time anyway. I do think those processes are occurring now.
Representative Dixie, Representative Mitchell.
Yeah, thank you, Mr. Chair. Yeah, what has necessitated the need of this? I'm trying to figure out because, last night I went to the tourism reception and they were bragging about how tourism had hit over $2 billion, and how it was greatly increasing. Everything seems to be going right, but this seems to be like, I kind of look at this amendment as this is Iran right here. You break it and you own it, So, our tourism in Nashville seems to be going fairly well, but looks like you're trying to raise gas prices another $1 or so here is what you're doing. So please tell me, what's the necessity of this bill?
Chairman Hawk.
I'm not trying to raise gas prices, so I'm not quite sure where that came from. We're talking about ways to handle traffic in both automobile traffic as well as pedestrian traffic, and the best way to do that, and that's what's being deemed necessary through this legislation.
Representative Mitchell.
Is it traffic of pedestrians or commuters, or is it making sure bar owners get their beer trucks when they want them? I'm just trying to figure that out.
Chairman Hawk.
It's all about commerce. You can use it whichever way you want to. It's all about commerce within these tourism development zones across the state of Tennessee is what it's all about.
Representative Mitchell.
But I'm just trying to get to the heart of the issue, where it's coming from, and let's just be straight out there honest with everybody that, it's not about we want to protect, the tourists, or we want to protect pedestrians, or we want to protect the commuters or the citizens. No, it's a handful of people. We're trying to do everything we can for them, whether it's to take over an airport so they can build themselves a hangar, or we got to make sure their beer trucks are pulling in right when they want them to.
Chairman Hawk.
Thank you. And some people have had longer days than others, so I understand that completely. We're talking about tourist development zones, which are Davidson County, Nashville, Hamilton County, Chattanooga, Knox County, Knoxville, Shelby County, Memphis, Sevier County, Pigeon Forge, Sevierville. So we're not picking on anybody. This is something that is used to improve tourism, increase our commerce in the state of Tennessee, and allow the flow.
Representative Mitchell.
I missed Greenville in that list. Did you miss that one?
Chairman Hawk.
I would love to have a tourist development zone in Greenville. Will you help me propose that? Let's bring it on in.
Is there any other questions? Any other discussion? Is there objection to the question? We're voting on Amendment 14107. Madam Clerk, open the voting board. Members, please cast your vote. Has every member voted? Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 4 ayes and 2 noes.
The ayes prevail. The amendment 14101 goes on House Bill 2366. We're back on House Bill 2366 as amended. Is there any other discussion? Seeing none, is there objection to the question? Hearing none, we're voting on House Bill 2366 as amended. Madam Clerk, open the voting board. Members, please cast your vote. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 5 ayes and 2 noes.
The ayes prevail. House Bill 2366 as amended moves to the next available calendar, state and local government.
Thank you very much, Chairman and members. Thank you.
Chairman Crawford, you're recognized for what purpose?
I'd like to make a motion to adjourn, subject to call of the chair.
Have a motion and a second. Is there objection to the question? Hearing none. We're adjourned at the call of, subject to the call. We're adjourned and closed subject to the call of the chair.